good, Nick. How are you doing?
Good. So another episode of PLA. We've got two questions we're going to deal with today. And I'll go through yours first. So we've got an agent who's written in. They've basically said that they've got a procurement lease that was signed for a period of 9 months. The tenant has been in occupation for a little bit more than a month and has paid in full in advance to the landlord. The landlord is a natural person and the tenant is a company in the circumstances. And the tenant has just given 20 business days notice to terminate the agreement. What our writer wants to know is what are the landlord's rights and or what penalties can be applied to the tenants in the circumstances. There's a caveat to this in that the agent says they don't think it's going to be easy to rent the property because the owners are coming back and presumably going to take occupation of the premises in January 2026.
So the basic question is whether the Consumer Protection Act applies to lease agreements and when it applies to lease agreements, but more importantly, what the implications are of the CPA on the lease agreements themselves. Now, Section 14 of the Consumer Protection Act is basically the first place that you'd look at when it comes to trying to assess whether a lease agreement falls within the ambit of the Act. The reason for this is Section 14 deals with fixed term agreements. In the lease agreement, more often than not, is a fixed term agreement unless it's on a month-to-month basis. Now, in these particular circumstances, the lease agreement was for 9 months. But if it's for 12 months, doesn't matter. It does tick the box. It is a fixed term lease agreement. Now, the CPA is excluded if the lease agreement is between two juristic persons. So as an example, this would be a company is the landlord and a company is the tenant. CPA doesn't apply. And then one doesn't need to worry about all the protections afforded by the CPA. But in this particular instance, the landlord is a natural person, so an individual like you and I, and the tenant is a company. So only one of those people or persons is actually a juristic person. So another test to find out if the Consumer Protection Act applies is to look at the juristic person and assess the juristic person's annual turnover and if it's over 2 million rand. Now, if it is over 2 million rand, then the CPA will not apply. Why? Because the juristic person is considered to be more sophisticated in the sense that they're able to handle their affairs and they're not vulnerable to exposure by or pressure by a landlord. If it's under 2 million rand, then the argument there is that obviously they are more vulnerable and the CPA should offer protections to the tenant. So one has to assess these, and those are the most typical tests, especially when dealing with juristic persons and fixed term agreements and the like. Now, if it so happens that the Consumer Protection Act does not apply, then the fortunate thing is the law as it stands applies. Now, under these circumstances, there was a 9-month lease. Everything was paid in advance. Now the tenant wants to cancel, this company wants to cancel the lease early after 3 months occupation, 6 months left on the lease, and the landlord is obviously aggrieved by this because the landlord is going to struggle to find another tenant, given that the landlord wants to move back in after the 6-month period. Now this gets interesting. So if the CPA doesn't apply, then there'd be a right in terms of our law regarding damages to actually claim and retain some of the rental, if not all the rental, based on the fact that there's a period of the lease left. And if the landlord did attempt to try and find somebody else and they were unable to, there would actually be a damages claim against this tenant. Because remember, the tenant is not entitled to cancel the lease early. Now, the Consumer Protection Act applies. It's an entirely different story. The Consumer Protection Act allows for a 20 business day notice period if the tenant wants to terminate an agreement, in this instance, a lease agreement, early. The tenant is entitled. So this is a right they have in terms of the Consumer Protection Act. You cannot stop them at all, right? in terms of the law, if the CPA doesn't apply, they're not entitled to cancel. So if they leave and they renege on the agreement, that's normally why you're entitled to claim damages and may even be able to retain the amount paid in advance. Here, unfortunately, this is their right. However, it's subject to the qualification that if they cancel early, there could be a reasonable cancellation penalty. And this is the debate amongst all practitioners, is what is reasonable. Now, the interesting argument here, and this is the debate that I was having with Nick, is usually you look at 2 months, 3 months, and you say, well, what's reasonable is the period of time it would take me to place a new tenant. Simple, right? And that's fair, right? If it takes you 2 to 3 months to place a new tenant, it would be reasonable to keep 2 to 3 months of rent as an example until you're able to place a new tenant. There's a few factors to bear in mind, but that's always been the approach that I've had. Is you look at the remaining period of the lease, you try figure out how long it would take you to find a new tenant and place yourself in a position where you're able to just continue renting out this property, and whether there's any associated costs or inconvenience with this. But in this instance, the landlord wants to move into the property again. And this lease agreement was for 9 months. So provided that it was clear, crystal clear, that this agreement was special, it was a 9-month lease because the intention was for the landlord to move in. It's a difficult lease to enter into because it's 9 months, very random number. You already get 9-month leases. So it was special. It was a lease that the landlord specifically looked for and acquired. But now, unfortunately, the tenant wants to exit this lease. And there is no way, or very difficult for the landlord to now go find someone for the remaining period, 6 months. So in my gut is telling me that if the landlord goes out and tries to at least find someone for the 6 months, but is not able to, and if the tenant knew that this was a special lease and that the landlord had intentionally entered into it with both parties knowing that this 9-month period was an imperative, there is a possibility that the reasonable cancellation penalty won't simply be 1 or 2 months, but it could be more. So this is something to bear in mind. There's multiple factors that need to play a part in that determination, but it is a different way of looking at when a reasonable cancellation penalty is due and when it isn't.